Veterans, Are You Getting Everything You Are Owed? By Tony Hinson. As a veteran myself, I am fortunate to work with many of my fellow service members in developing their estate plan and exploring any potential benefits available through both the Department of Defense and the Department of Veterans Affairs, also known as VA. One of the most overlooked but potentially life-changing benefits is aid and attendance, also known as A&A. This program has traditionally used a household income cap to determine eligibility and to determine the amount of the benefit. With a general limit of $80,000, but no set asset limit, claims approvers often applied inconsistent and arbitrary standards in reviewing applications. The rules for eligibility for A&A changed significantly in 2018 and applied to all new applications. General test for eligibility. The veteran applying for this benefit must be 65 years of age or officially disabled. The veteran must have 90 days of active duty service, of which 1 day must fall within the eligible wartime periods listed below, and their discharge must not be determined to be dishonorable by the VA. The veteran must be disabled so that they require assistance with activities of daily living, but their disability need not be service-connected. Finally, a surviving spouse applying for benefits, if not a veteran themselves, must have been married to the veteran at the time of the veteran's death and must not be remarried at the time of the claim. Income eligibility test. Generally, the joint countable income of a veteran and spouse must fall below the maximum pension available under the program they are applying for benefits. For a married couple applying for A&A, that current maximum for 2021 is $27,549, and the available pension would be the difference between the maximum available and the couple's countable income. However, there are certain deductions from gross income that are allowed when computing countable income, and some income sources are not included. Notably, unreimbursed medical expenses over 5% of the maximum available benefit may be deducted from income, and SSI and welfare benefits are not counted in income. Asset eligibility test. Under the new rules, the VA uses the maximum community spouse resource allowance, also referred to as the CRSA, as a bright line test to determine the net worth limit for A&A eligibility. Currently, this amount is $130,773. Much like other limits under federal law, the amount is adjusted annually for inflation. Additionally, there are several rules used to determine the applicant's net worth. Number 1, countable income included in net worth. The annual countable income of the applicant is included in the net worth computation. Number 2, primary residence excluded from net worth. The value of the applicant's home and accompanying real estate not to exceed 2 acres is excluded from this asset limit. If the home is sold, the proceeds must be used to purchase a new home in the same calendar year, which would result in a very tight time frame if a home is sold at the end of the year. If the residence is offered as a rental, the rental income is included in countable income and also included in net worth as explained above. Number 3, all other assets included in net worth. All other assets owned by the applicant and spouse are included with any debts or liens deducted from such assets. It is important to note that there are no qualified annuities available to exclude as with Medicaid, and all assets are included regardless of whether they are listed for sale at the time of the application. Notably, transfers made to a single premium immediate annuity, also known as a Medicaid annuity, will trigger a possible penalty under the look-back period, discussed below for the entire amount transferred to the annuity. 3-year look-back rule. The VA imposes a 3-year look-back period for disqualifying transfers with a maximum 5-year penalty period as a result of such transfers. If a disqualifying transfer is found to have occurred within the look-back period, then a penalty is imposed. The penalty is a period of ineligibility which runs from the date of the disqualifying transfer. If the VA imposes a penalty for such a transfer, the applicant has 60 days to recover the asset and must, within 90 days, provide notice to the VA that the assets have been returned. Penalty period. To compute the period of ineligibility due to a disqualifying transfer, you take the portion of the value of the asset which, if not gifted, would have caused the applicant to exceed the asset eligibility limit and divide that number by the maximum monthly ANA benefit payable to a veteran with one dependent, regardless of the particular veteran's dependent status. That number rounded down is the number of months the applicant is ineligible from the date of the gift. As an example, assume a couple has a net worth of $150,773 and gifts away an asset worth $25,000. Before the gift, the couple had an excess net worth of $150,773 minus $130,773, which equals $20,000. The maximum monthly ANA benefit for 2019 for a veteran with one dependent is $27,549 divided by 12, or $2,296. Dividing $20,000 by $2,296 results in an 8.71 month penalty period, rounded down to 8 months. This period then runs starting the month after the transfer. Dependent indemnity compensation, completely separate from ANA, is an exciting benefit available to surviving spouses and, in some cases, parents and children of deceased service members. Unlike ANA, dependent indemnity compensation, also known as DIC, is not limited by income or assets. It is available if the service member or veteran dies on active duty, dies from a condition which is service-connected, dies after being deemed 100% disabled for 10 years for VA purposes, was a POW, and 100% rated for 1 year, or dies due to VA medical negligence. The benefit ranges from $1,358 per month to nearly $3,000 per month. It is important to remember that many ailments are automatically deemed service-connected for Vietnam veterans due to Agent Orange exposure. I encourage you to visit www.va.gov and review the pages regarding DIC. Seek assistance. While the ANA and DIC rules may seem burdensome or complex, my fellow veterans and their dependents should explore every benefit available, including ANA and DIC. I encourage you to seek the help of great programs and services available to you, such as www.veteransaidbenefit.org and www.veteranaid.org.